The entry of appearance and other red tape when you're sued for debt. Brought to you by Kenneth Chabert at yourlegallagotte.com. Your advantage if you're being sued by debt collectors. If you're going to defend yourself in a case brought by a debt collector, there's some basic stuff you need to know. You need to know what an entry of appearance is, what the style of the case is, and how you should sign your pleadings and what that signature means. Don't yawn. These three things are so boring and trivial that they're easy to overlook and hard to talk about in a way that won't put the audience to sleep. But you have to know them if you're going to defend yourself, so prop up your eyelids and hang in there with me. Start with the entry of appearance. An entry of appearance is your formal introduction to the court, your announcement that you will be defending yourself. When lawyers do it, the entry includes a bar number, proper address, and the assertion that the lawyer will be representing certain specified clients in the matter. When there are several parties in the suit, that can be helpful. When you are representing yourself, the entry becomes more of a formality. And sometimes the court waives this formality. And if you've begun representing yourself but haven't filed an entry of appearance, don't sweat. So now, style of the case. The style of the case, also called the caption, is its name. Say, debt collector versus Joe consumer, plus the case number and some information about the court, the jurisdiction. Usually it'll say state court of your state, county of your county. Every pleading will have a caption on it. That's what the rules say. So if you're being sued, you'll find the style on the first page of the petition. You can just copy it. And if you want to sue somebody, bring the lawsuit that is, just take a look at another case that's been filed in the same court to see what the information is put on it. That's probably easier than looking it up in the rules of civil procedure. And don't worry, they'll tell you if you get it wrong. Now let's talk about the signature. Every pleading must be signed. That is, literally signed by hand. The rules also require some information below the signature, a printed or typed version of your name, your phone number, and address. And these days most jurisdictions also require an email address as the litigation process has become increasingly more computer-driven. You can either just include it or check your local rules. Failure to sign means the pleadings could get stricken if you don't fix the problem immediately, if it's pointed out, which it will be. And the problem with a lot of these things is not so much that you'll lose your pleading or any rights, it's that you'll be required to fix the problem very quickly, which can present a scheduling problem for you. When a person signs pleadings, the signature generally is required to signify that that person has done some reasonable checking of the facts and legal claims that are in the pleading. And they've found that they are at least arguably correct. And that's why I often have argued that the way debt collectors use computer records, which are generated by the business and are never checked by the lawyer, and automated processes which can take a lawsuit from, can take a debt from, all the way from somebody calling you and harassing you to filing the lawsuit without a lawyer actually really intervening. I claim sometimes that those are unfair debt collection practices because they break this rule. If the court finds that a person was too far afield in the factual claims, it can punish them with what are called sanctions. And depending on the facts, it could also be a violation of the Fair Debt Collection Practices Act, too. It does take a lot, even for lawyers, to break this rule. Non-lawyers, in general, are held to much lower standards still and can, as a practical matter, say almost anything without worrying about sanctions. Of course, you will want to make powerful and reasonable arguments based on facts that you can prove so that you can win your case. You may not consider this video or anything I say in this or any video as legal advice. I can't give you legal advice, but as a former lawyer, I do know the legal process and debt law very well. So use what I say as a source of information and apply your own judgment to your case. To get more help on fighting debt collectors and their lawsuits, go to yourlegallegout.com. Get my litigation manual and forms, and defend yourself from the debt collectors.